So, very good evening, all the participants. Today, we would like to have a brief overview of the various allied laws. So, let me share my screen with you. So, this is the PPT. I hope you have already received this.
Yes, sir.
Okay. So, now on this. इसको बड़ा कैसे करना? यहाँ जूम नहीं होता ये.
यहाँ से करना है सर।
हाँ.
वो राइट हैंड साइड से करो, राइट हैंड साइड से।
अच्छा, ये वाला. इसी से.
हाँ,
ये थोड़ा ज्यादा बड़ा होगा. ठीक है, इतना ही ठीक है, कोई बात.
दिखता है सर,
बस
दिखता
इतना
है।
ठीक है, ठीक है, ओके.
हम्म, हम्म।
So now what about MSME? In MSME, you have to remember two, three things. Number one, what is the cutoff date? What is the cutoff date for your syllabus? 4th of February 2025. Because this MSME definition has undergone changes after that period also. But that is not applicable for your syllabus. This is the first thing you have to remember. I have already given you the detailed PPT on MSME. So what are the main points you have to remember in this? Number one is that earlier there was a separate criteria, but now there is a composite criteria. And what is that composite criteria? Here, if any enterprise is classified as MSME, so we have to see both the things: investment in plant and machinery or equipment and turnover.
No.
Now, what is important? Important is that you don't have to look at the investment in building, investment in furniture, right? Investment in land. Only investment in plant and machinery or equipment and turnover. And turnover, whether it is defined in IBC, the answer is no. Turnover is defined in Companies Act. And what is the definition of turnover? So whatever is the definition of turnover, what you have to remember is that export turnover has to be specifically excluded, right? So export turnover is not included. If you see the definition of turnover, let me see the definition of turnover. Section 2. Yes. So turnover as per section 2, subsection 91 of Companies Act means the gross amount of revenue recognized in the profit and loss account from the sale, supply or distribution of goods or on account of services rendered or both by a company during a financial year. This is the definition, right? Now, what is the criteria? Micro enterprise, if investment does not exceed 1 crore rupees and turnover does not exceed 5 crore rupees. Small enterprise, investment does not exceed 10 crores and turnover does not exceed 50 crores. You have to specifically remember that word and is used. So both the criteria have to be fulfilled. Suppose investment is 1 crore, but turnover is 6 crores. Then where it will be classified? If
Small,
investment
sir.
is
Small.
small,
Small, small, small.
yes. So it will be moved to the next criteria. Small enterprise, investment does not exceed 10 crores and turnover does not exceed 50 crores. And medium enterprise, investment does not exceed 50 crores and turnover does not exceed 250 crores. So investment, if it exceeds 50 crores and turnover if it exceeds 250 crores, then it is no more an MSME, right? Regarding export turnover, export of goods or services are excluded while calculating the turnover for classification. Manufacturing versus service, the distinction between manufacturing and service sector for classification was removed. Right. Now regarding Udyam registration, whether Udyam registration is mandatory. As per the latest amendment in IBC Udyam registration, you have to cite. Suppose you are making an application for pre-pack, then you have to give the Udyam registration. But as per our syllabus, it is so long as it is classified as MSME, it's okay. Regarding Udyam registration, registration is done online through the Udyam registration portal and it is based on self-declaration. Now, in case of what happens in case this enterprise crosses the limit, right? So in case of upward graduation, if an enterprise crosses the limit, it maintains its prevailing status for 1 year after the close of the financial year, right? And in case of reverse graduation, if an enterprise falls below the limit, it continues in its present category until the close of that financial year, right? Now, Section 3 of this MSME Act says that there will be established a national board to examine factors affecting MSME and to advise the central government on various issues affecting the MSME sector. Section 11 talks of the procurement policy and it says central government may notify preference policies for procuring goods or services from micro and small enterprises. So, MSMEs are given preference in case of central government purchases, right? You cannot force private sector to purchase from them, but the government can do it, right? So it says, Section 11 says that the central government may notify preference policies, like most of the procurements in case of government are done through DGS&D. So they will instruct them accordingly. Payment, mandatory payment, Section 15. So Section 15 gives protection to MSME that in case somebody is buying from an MSME, so it says that buyer must make the payment on or before the agreed date and which cannot exceed 45 days from the date of acceptance, right? There is a question of appointed day also. And appointed day says if no date is agreed, payment is due on the appointed day 15 days from the date of acceptance, right? Interest on delay. Section 16 talks of interest on delay. It says compound interest with monthly arrests is payable at 3 times the bank rate notified by the RBI in case payment is delayed. Liability to pay, Section 17. So Section 17 says that the buyer is able to pay the amount with interest for any goods supplied or services rendered. Section 18. Section 18 talks of reference to the Micro and Small Enterprises Facilitation Council. So if there is any dispute regarding payment, so any party to a dispute regarding payment may make a reference to the Micro and Small Enterprises Facilitation Council. MSME jurisdiction, Section 18(4). So it says the council has jurisdiction to act as an arbitrator or conciliator in any dispute between a supplier and a buyer. Conciliation first. Section 18(2). On receipt of a reference, the council shall first conduct conciliation either itself or via an institution. Then arbitration stage, Section 18(3). If conciliation fails, the council shall either take up arbitration itself or refer to it to an institution. Section 19 talks of pre-deposit in case of an appeal. An application to set aside a council decree is not entertained unless the appellant deposits 75% of the amount. Regarding audit disclosure, Section 22. So companies required to be audited must specify unpaid amounts and interest due to MSMEs in their annual statement of accounts. And tax disallowance, Section 23. Interest paid or payable under this act cannot be claimed as a deduction for income tax purposes. Section 24 talks of the overriding effect. Sections 15 to 23 have effect notwithstanding anything inconsistent contained in any other law. MSME composition, Section 21, consists of not less than 3 and not more than 5 members, including a director of industries as chairperson, right? So this is regarding the composition of the facilitation council. Okay. Then small enterprise status. Delayed payment protection, section 15 to 23 apply only to micro and small enterprises, not medium. This is also important, right? So this protection regarding delayed payment, it applies only to micro and small enterprises. Then CPACE winding up. LLPs or companies can use CPACE for accelerated exit, which is a significant relief for MSMEs, right? Penalty for default, section 27. So failure to furnish information or filing memorandum can lead to fines ranging from 1,000 up to rupees 10,000. Advisory committee, section 7, subsection 2. The central government consults an advisory committee before notifying any change to the classification limits. Now TREDS platform, TREDS platform. Trade receivables discounting system allows MSMEs to auction trade receivables to improve liquidity. IBC prepackaged CIRP. IBC section 54A. So MSMEs are eligible for the prepackaged insolvency resolution process, which is faster and debtor in possession regime, right? Professional insight. For a practicing professional, section 23 is a critical compliance point. Since the interest on delayed payment to MSMEs is not tax deductible, it effectively increases the financial burden on defaulting buyers beyond just the interest rate itself. Furthermore, as an insolvency trustee, you must prioritize the identification of MSME creditors, as they often have specific protections under the resolution plan and the right to initiate the prepackaged insolvency mechanism. So this is the basic regarding MSMEs. ठीक है, अब देखो इतने 5 मिनट के अंदर हमने क्या किया, एमएसएमई को मोटा मोटा कवर कर लिया, ठीक है. एंड दिस इज ऑल जनरेटेड थ्रू एआई, सो यू कैन चेक द थिंग्स ऑन योर ओन ऑल्सो, ठीक है. अगर कोई इनकरेक्टनेस है तो यू कैन पॉइंट इट आउट टू मी, बट दिस इज बेस्ड ऑन द पीपीटी वी गेव देम. इफ यू give them proper inputs, so they will give you proper outputs. Narinder ji, your take on this MSME के बारे में, anything else which is not
नहीं
covered?
सर specifically for the purpose of investment in plant and machinery, there
हाँ,
are some like
right.
pollution
So
control
there are
equipment.
some exclusions, this research and development equipment,
हाँ.
post
Yes.
this pollution control devices, है ना?
Yes sir, yes sir, yes.
वो चीजें, हाँ, right, हाँ. So that is not covered here. Thanks for pointing out. So
हाँ सर.
certain things are excluded from this investment limit. Cost of pollution control devices is excluded. Any expenditure on research and development is excluded. और क्या है? और भी कुछ है?
Pollution control sir.
हाँ, पोल्यूशन कंट्रोल हो गया, R&D हो गया, और
Yes sir, बस it's there is only two sir.
जस्ट ये तो पूरा एक्ट है. यस, ये वाला, ये मैं आपके साथ शेयर करता हूँ. दिस पीपीटी आई ऑलरेडी शेयर्ड विद यू. एक मिनट, स्टॉप शेयर करके, और ये मैं ये वाला शेयर करता हूँ आपसे. तो यू आर रेफरिंग टू दिस, है ना? कॉस्ट ऑफ पोल्यूशन कंट्रोल, रिसर्च एंड डेवलपमेंट, इंडस्ट्रियल सेफ्टी डिवाइसेस एंड सच अदर आइटम्स एज मे बी स्पेसिफाइड. ठीक है, तो ये एक्सक्लूडेड है. एंड डब्ल्यूडीबी यू हैव टू टेक. ठीक है, बाकी पूरा डिटेल्ड पीपीटी तो है आपके पास, है ना?
हाँ सर.
हाँ, बाकी ये कि ये इंपॉर्टेंट इंपॉर्टेंट पॉइंट्स है, इसमें वो वाला और डाल देंगे.
हाँ.
ठीक, वेरी गुड. तो नेक्स्ट कवर करते हैं इसके अंदर. एक कवर हो गया हमारा, क्योंकि यहाँ रियल चैलेंज क्या है कि भैया जल्दी से जल्दी कितना कवर कर सकते हैं हम लोग.
एक
तो
सर रेरा का भाई शॉर्टेस्ट है सर, पर
है,
रेरा का नहीं लिया है.
हाँ,
रेरा.
हाँ
RERA is also very much shorter, like 9 slides. बट
हाँ हाँ।
हाँ सर।
हम्म।
उसके बाद
अभी देखते हैं, सरफेसी
हाँ
देखते
सर,
हैं।
नो इशू सर, नो इशू
हाँ,
सर। यस सर।
सरफेसी में क्या कहता है?
हाँ सर।
सबसे पहले तो इसका नाम, इसका नाम क्या
सबसे
है? सिक्योरिटाइजेशन एंड रिकंस्ट्रक्शन ऑफ फाइनेंशियल एसेट्स एंड एनफोर्समेंट ऑफ सिक्योरिटी इंटरेस्ट, ये नाम है पूरा। कई बार नाम के ऊपर ही क्वेश्चन पूछ लेता है वो, कि व्हाट इज द फुल फॉर्म ऑफ सरफेसी, अलग अलग नाम दे देगा। सो इट इज सिक्योरिटाइजेशन एंड रिकंस्ट्रक्शन ऑफ फाइनेंशियल एसेट्स एंड एनफोर्समेंट ऑफ सिक्योरिटी इंटरेस्ट। ठीक है। नॉन एप्लीकेबिलिटी, where it is not applicable, it does not apply to agricultural land in case of cases below 1 lakh, or where the remaining debt is less than 20% of the principal amount. Debt threshold currently applicable for commercial debts of rupees 20 lakhs and above. ठीक है। NPA requirement, section 2 subsection O, enforcement can only begin after the account is classified as NPA as per RBI guidelines. Then secured creditor, only secured creditors, banks, financial institutions, asset reconstruction companies can invoke the provisions of SARFAESI. Unsecured creditors cannot take shelter behind this act. Then ARC definition. What is asset reconstruction companies? So asset reconstruction companies must be registered with the RBI to carry out securitization. So there are detailed provisions regarding this turnover, etc., uh, which RBI mandates that okay, in case you want to register yourself as an ARC, so you have to maintain certain things regarding security interest, right, title or interest of any kind created upon property in favor of a secured creditor. Demand notice, section 13(2). This is the first step in case of SARFAESI. So 60 days notice is given to the borrower to discharge the liabilities in full. Objection by borrower. Section 13 subsection 3A says that the borrower can raise objection within the 60-day period and the creditor must reply within 15 days. Section 13(4) talks of the possession of assets. If the borrower fails to pay, the creditor can take possession of the secured assets. Authorized officer. This authorized officer must be an officer not less than a chief manager of public sector bank or equivalent. Assistance of DM or chief metropolitan magistrate. So in case secured creditor faces any resistance from the borrower, so then secured creditor can request the district magistrate or chief metropolitan magistrate to take physical possession. Surcey registration. Section 26D. Secured creditors cannot exercise right of enforcement unless the security interest is registered with Surcey. So Surcey is basically a registry, like NESL is the registry in case of IBC. So Surcey is similar registry wherein you are required to pay certain fees, and whenever you create any security interest, when any security interest is satisfied, so in that case you have to register that thing on payment of certain fees. Survey timelines. Section 23 talks of the particulars of creation or modification. They must be filed within 30 days and it is extendable by another 30 days with fees. Okay. Section 13(4)(b) talks of the management takeover. So the creditor has the right to take over the management of the business of the borrower and he may run the business or he may hand it over to some asset reconstruction company. Sale of assets. Section 13(4). So creditors can sell the assets via public auction, private treaty or tender. Right to sue. Section 13(10). If sale proceeds are insufficient to cover the debt, the creditor can file an application in DRT for the balance. Appeal to DRT. Section 17. So any person aggrieved by the creditor section under section 13(4) can appeal to DRT within 45 days. DRT time limit. DRT is required to dispose of the application within 60 days and it is extendable up to 4 months. Appeal to DRAT. Section 18. So appeal against a DRT order must be filed within 30 days. Pre-deposit in case of appeal. Section 18(1). So borrower must deposit 50% of the debt to appeal. So DRET can reduce this to 25%. Security receipts. Security receipts are issued by ARCs to qualified buyers representing an undivided interest in financial assets. Qualified buyers. These includes financial institutions, banks, insurance companies, trustees or ARCs. Exempted liens. A lien on goods or money under the Indian Contract Act or Sale of Goods Act is not a security interest under SARFAESI. Personal guarantors. So SARFAESI can be invoked against the property of a personal guarantor even without proceeding against the principal borrower. Overriding effect, section 35. So provisions of SARFAESI override any inconsistent provisions in other laws. Civil Code bar, section 34. So no civil court has jurisdiction to entertain any suit in respect of matters which a DRT or DRAT can decide. Modification of charge. Any modification or satisfaction of the security interest must also be filed with SARFAESI. J&K jurisdiction. For borrowers in J&K, recovery applications may be filed with the district court having jurisdiction. IBC immunity, section 238. So IBC prevails over SARFAESI in case of conflict during the moratorium period. So as an insolvency professional, it is vital to note that while SARFAESI allows for swift recovery, section 14 of the IBC imposes a total moratorium during CIRP period. But that moratorium is lifted during liquidation. So during liquidation, a secured creditor can take action, but not during CIRP. If a bank has taken symbolic possession under SARFAESI, but not yet sold the assets before the insolvency commencement date, the asset must be handed over to the RP to form part of the liquidation estate. Registration with SARFAESI is now a mandatory condition precedent for any bank to initiate these recovery actions. So this is regarding SARFAESI. Okay? So we have covered in just 20 minutes 2 laws. Okay? Basic बात है. बाकी if you want detailed, तो detailed PPT also I have given it to you. But this is the minimum you must remember. Any other point in SARFAESI? What is important? Number one is that 60% limit. In case of a joint consortium, so 60% of the creditors must agree in case they want to take action under SARFAESI. Now, in case the assets or business is taken over by the secured creditor, then they may get a shareholding also. In case shareholding is given to the secured creditor, then management will not be transferred. बाकी और डिटेल्स है काफी सारी, वो डिटेल्स आपको सारी पीपीटी के अंदर मिल जाएगी, बट इससे आपको ना बेसिक आइडिया मिल जाए. नाउ लेट अस सी दिस आर्बिट्रेशन एंड कंसीलिएशन एक्ट. एनीथिंग एल्स ऑन SARFAESI, नरेंद्र जी?
सर कवरिंग ऑलमोस्ट डन सर. अच्छा है सर.
अब अगला देखते हैं आर्बिट्रेशन एंड कंसीलिएशन एक्ट. So it consolidates laws relating to domestic arbitration, international commercial arbitration and conciliation. ठीक है? International commercial arbitration, section 21F. So arbitration where at least one party is a foreign national, body corporate or government. So that is known as international commercial arbitration. Written communication, section 3. Section 3 says that written communication is deemed to be received if it is delivered to the addressee personally or at their place of business or residence. ठीक है? Section 14 talks of waiver of right. So a party who proceeds with arbitration knowing a requirement has been ignored waives their right to object later. ठीक है? Judicial interpretation. So once you enter the arbitration process and you know that okay, particular requirement has been ignored, then you cannot object at a later date. This is the meaning. Judicial intervention, section 5. So minimal interference, no judicial authority shall intervene except where specifically provided in the act. Section 7 talks of the arbitration agreement and it says it must be in writing, can be a clause in a contract or a separate agreement. Sometimes in the agreement there is a clause that okay, in case of dispute, the matter will be referred to arbitration, and it could be by way of a separate agreement also. So both things can do. Reference by court, section 8. If a suit is filed in a matter covered by an arbitration agreement, the court must refer parties to arbitration. ठीक है. Interim measures, section 9. Parties can apply to court for interim protection before, during, or after the award, but before enforcement. Number of arbitrators. This is important. So parties are free to determine the number, provided it is not an even number. So even one arbitrator could be there, 1, 3, 5, right? But it should not be even, because in case of difference of opinion, one vote can prevail at least. That is possible only when it is odd in number. ठीक है. Appointment. Default. Section 11. If parties fail to appoint an arbitrator, the Supreme Court or High Court or designated institution may appoint an arbitrator to decide the matter. Grounds for challenge. Section 12. An arbitrator must disclose any interest that may raise justifiable doubts about their independence or impartiality. 7th schedule. Section 12, subsection 5. So lists relationships, for example, employee, consultant, that makes a person ineligible to act as an arbitrator. ठीक है. Competence of tribunal, section 16. So it says the tribunal can rule on its own jurisdiction, including objections to the agreement. Interim measures. Tribunal, section 17. The tribunal has the same power as a court to grant interim measures during the proceedings. Place of arbitration, section 20. Parties are free to agree on the seat, failing which the tribunal determines it based on its convenience. Statement of claim, section 23. Must be completed within 6 months from the date the arbitrators received notice of appointment. Default of a party, section 25. If the claimant fails to communicate their claim, the tribunal shall terminate the proceedings. Expert appointment, section 26. The tribunal may appoint experts to report on specific issues unless otherwise agreed by the parties. Fast track procedure, 29B. So parties may agree to a fast track process where the award is made within 6 months based only on written pleadings. Time limit for award, section 29A. Award must be made within 12 months from the completion of pleadings, and it is extendable by 6 months by mutual consent. Mandatory stamping. An unstamped or insufficiently stamped arbitration agreement is not enforceable until the defect is cured. Form of award, section 31. It must be in writing, signed by members, and state the reasons upon which it is based. Section 32 talks of termination. Proceedings end with the final award or by an order of the tribunal, for example, if the dispute is settled. Setting aside award, section 34. Recourse to court to set aside an award is limited to specific grounds, for example, incapacity, public policy, fraud, etc. Patent illegality, section 34(2)(a). Domestic awards can be set aside if they are vitiated by patent illegality appearing on the face of the award. Finality of award, section 35. An arbitral award is final and binding on the parties and persons claiming under them. Section 36 talks of enforcement of an award. So an award is enforced under the Code of Civil Procedure as if it were a decree of the court. Automatic stay, removal, section 36 of section 2. So filing a challenge under section 34 does not automatically stay the award. A separate application for stay is required. Okay. Now regarding appeals, section 37. So specifies limited orders like refusing to enter to arbitration or setting aside an award that are appealable. Conciliation, section 61 to 81. A non-adversarial process where a third party helps reach a settlement. A settlement agreement has the status of an award. Okay. Now, what happens during CIRP, during IBC? So in insolvency matters, if a corporate debtor is involved in an ongoing arbitration, the section 14 IBC moratorium will generally stay the proceedings if they result in a net outflow of the debtor's assets. However, if the arbitration is for the benefit of the corporate debtor to recover money, the resolution professional or liquidator may choose to continue the proceedings, right? So there should not be a net outflow. If something is coming to the fold of the corporate debtor, then it's okay. Furthermore, any arbitral award passed prior to the CIRP must be admitted as a claim by the creditor in accordance with the quantified amount in the award. Right. So this is regarding arbitration. Narendra ji, anything more you would like to add? Or
No, no, sir.
anybody
It's
else?
okay, sir. Done, sir. Done.
Okay. Next is नेक्स्ट इसमें आ रहा है आपका आरडीबी एक्ट, रिकवरी ऑफ डेट्स एंड बैंक्रप्सी एक्ट। रिकवरी पहले तो पूरा नाम होता था इसका आरडीडीबी एक्ट, रिकवरी ऑफ डेट्स एंड ड्यूज फ्रॉम बैंक्स एंड फाइनेंशियल
We
to
have
banks and
mediation
financial
also,
institutions.
mediation act also in the syllabus.
Yes. Mediation Act is also there. Correct. I'll share the points regarding Mediation Act also. Main object of RDB Act is, so first of all let us complete this and then we'll go to जैसे Mediation Act है, PF है, बहुत सारे acts हैं, DPDP भी है. So Recovery of Debts and Bankruptcy Act 1993. So the preamble says the main object of the act is expeditious adjudication and recovery of debts due to banks and financial institutions. Applicable threshold, it applies where the amount of debt is 20 lakhs or more. Earlier it was 10 lakhs, now it is 20 lakhs, or as notified by central government. Definition of debt. Section 2G. It includes any liability inclusive of interest which is claimed as due from any person by a bank or financial institution. Nature of creditors. It applies to both secured and unsecured creditors, unlike SURFACE, which is for secured creditors only. Right? Adjudicating body. Section 3. Establishment of debt recovery tribunals to exercise jurisdiction. And debt recovery tribunals are situated located in almost all the major cities. Appellate body. Section 8. Establishment of debt recovery appellate tribunal. Jurisdiction bar. Section 18 says no court or other authority except Supreme Court and High Court under Article 226 or 227 has jurisdiction over these matters. Application for debt. Section 19. A bank or financial institutions makes an application to the DRT within whose jurisdiction the cause of action arises or the defendant resides. Concurrent action. Banks can pursue actions under both RDB and SURFACE Act simultaneously. Filing fees. So prescribed fees must accompany the application, capped at a maximum limit. Summons issues. 19(4). So DRT issues summons to the defendant to show cause within 30 days why relief should not be granted. 19(12). DRT has the power to pass interim orders, injunction, stay, attachment to prevent asset dissipation. Section 19(8) talks of counterclaim. So the defendant has the right to set up a counterclaim against the bank in the same proceedings. Admission of debt. Section 19(10). If the defendant admits the debt, the DRT may pass an order for payment immediately. Section 19(22). Certificate of recovery. After adjudication, the presiding officer issues a certificate to the recovery officer for execution. Section 7 talks of the definition of recovery officer. So recovery officer is an official responsible for executing the recovery certificate. What are the modes of recovery? It includes attachment, sale of property, arrest of defendant, and appointing a receiver. Garnishee proceedings. Section 28(3). So recovery officer may require any person indebted to the defendant to pay the money directly to the tribunal. Stay of proceedings. Section 27. So presiding officer can grant stay or time if defendant pays 25% as down payment. Appeal period. So appeal to DRT must be filed within 30 days from the date of the DRT order. Pre-deposit condition. Section 21. DRT will not entertain an appeal unless the appellant deposits 50% of the debt, but it can be reduced up to 25%. Right of representation. So parties can be represented by legal practitioners or their own officers. Limitation Act. The provisions of the Limitation Act apply to applications made to the tribunal. Power of review. So DRT has the power to review its own decisions. Section 31 regarding transfer of suits. So all suits pending in civil courts above threshold limit at the commencement were transferred to DRT. Overriding effect. The RDB Act has overriding effect over other laws, save for certain exceptions like IBC surface. IT Act schedules. Provisions of the second and third schedule of the Income Tax Act apply to recovery proceedings. Section 1921, death of defendant. If a defendant dies during proceedings, the legal representative can be substituted. Uniform procedure. Section 22, DRT is not bound by CPC but guided by principles of natural justice. Priority of debt. Section 31B, secured creditors have priority over all other debts and government dues. In the current legal landscape, the RDB Act serves as the primary adjudicatory mechanism for quantifying debt. However, once a moratorium under Section 14 is declared, all proceedings before the DRT against the corporate debtor are stayed. As a trustee, you must coordinate with the recovery officer to ensure that any assets already attached but not yet sold are brought into the liquidation estate CIRP pool for the benefit of all stakeholders. So this was regarding RDB Act. Now prevention of money laundering and prevention of corruption act. तो इसके ऊपर आपका कोई इनपुट नरेंद्र जी?
नहीं सर, कंटिन्यू प्लीज.
Okay. Now regarding this prevention of money laundering and prevention of corruption act. So what are the main points? The main object of PMLA is to prevent money laundering and confiscate property involved in or derived from laundering. ठीक है? Basically criminal proceeds. Administering agency. So Directorate of Enforcement, Department of Revenue, Ministry of Finance is the administering agency in case of PMLA. Money laundering, processing criminal activities to disguise their illegal origin to make profits appear legitimate. Dirty money, funds from illegal arms sales, smuggling, drug trafficking, bribery or computer frauds. Mainly. Placement. First stage is placement. Introducing illegal funds into the financial system, for example, in the case of small bank deposits. Then layering. Second stage. Continuous movement of funds to hide the true source or origin. And then integration. Final stage. So funds reach the legitimate economy, for example, real estate or luxury assets. Predicate offense. A scheduled offense that generates the proceeds of crime, the root cause for PMLA action. Investigating agency, police, customs, SEBI or CBI investigate the scheduled offense under their respective acts. Property. Property includes assets of any description, movable, immovable, corporeal, incorporeal, deeds or instruments. Provisional attachment. An order prohibiting the transfer or movement of property for a specified period. What is the attachment timeline? A provisional attachment order ceases to have effect after 180 days if it is not confirmed. Record retention. So seized records or property can be retained for 180 days, 6 months unless extended by the authority. Adjudicating authority. The body that confirms attachment orders and decides if property is involved in laundering. Burden of proof. In PMLA, the burden of proving that proceeds of crime are untainted is often on the accused. Now regarding Prevention of Corruption Act. The basic purpose is to prevent corruption by public servants and fight. One of the important points which we have missed in case of PMLA is the punishment. So in case it is relating to drugs, so it could be 3 years to 10 years. In case it is other than drugs, it could be 3 years to 7 years. That is one important point we have missed here. So that point we must remember. Regarding this Prevention of Corruption Act, वो वाला भी इंक्लूड कर देंगे. जो मिस कर गए ना इसमें थोड़े पॉइंट्स और डाल देंगे. दिस इज ऑल जनरेटेड थ्रू AI. तो चलो फिर भी कुछ तो बनाया है इसने, ठीक ही बनाया इसी बात में. Main object, Prevention of Corruption Act, to prevent corruption by public servants and fight bribery in public office. Public servant includes Government of India, state employees, local authorities, staff, judges and university employees. So even a cashier in a university is a public servant. Public duty, a duty in the discharge of which the state, the public, or the community has an interest. Corruption definition, taking gratification other than legal remuneration for performing an official act. Gratification, it is not restricted to money. It includes any valuable thing, favor, or undeserved treatment. Undue advantage, giving priority, preferential treatment, or adjusting tender codes for a bribe. Punishment, general, minimum 3 years, maximum of 7 years. Criminal misconduct, habitually accepting bribes, misappropriating public assets, or having disproportionate assets. Disproportionate assets, possession of money or property beyond known sources of income which cannot be explained. Prior sanction. So previous sanction from the government of India or state government is required to prosecute a public servant. Investigating officer, generally a police officer of the rank of assistant commissioner or DSP. Abatement, anyone who abets an offense, offers a bribe, is also punishable under the act. Special judges, central or state government appoints special judges to try offences under the act for speedy trials. Commercial organizations. So organizations can be held liable if a person associated with them gives a bribe to a public servant. Interplay with IBC. PMLA attachments can sometimes conflict with the IBC general moratorium. Courts often prioritize the PMLA if the property is as a result of proceeds of crime. Under PMLA, Section 32A, a corporate debtor is often granted. This Section 32A is in IBC. So a corporate debtor is often granted immunity from the liability of offences committed prior to the commencement of CIRP, provided the resolution plan results in a change of management. However, as a trustee, you must remain vigilant regarding provisional attachments by the ED, as these can significantly impact the liquidation value and the feasibility of a resolution plan. Now, Limitation Act. It is procedural in nature. It generally bars the remedy but does not extinguish the right. Section 2 talks of the applicability. So primarily, Limitation Act applies to civil cases, suits, appeals and applications, and not generally to criminal cases unless specified. Section 3 talks of the court's duty, and it says that a suit filed after the prescribed period must be dismissed even if limitation is not set up as a defense. So the courts can take suo motu cognizance of this Limitation Act. Section 4. If the period expires on a day when the court is closed, the filing can be made on the day it reopens. Section 5. Condonation of delay. Delay may be condoned in appeals and applications if sufficient cause is shown. Okay. But it does not apply to suits. So it may be condoned in appeals and applications. Section 6. If a person is a minor, insane or an idiot, the period starts only after the disability ceases. Section 7. In continuous disability, where one of the several joint creditors is under disability, time will not run against any until the disability is removed. Now, continuous running. Section 9. Once time has begun to run, no subsequent disability or inability to institute a suit stops it. Section 10. Trustees. No period of limitation applies to suits against express trustees or their representatives for recovery of trust property. Foreign contracts. Suits instituted in India on contracts entered into a foreign country are subject to the Indian Limitation Act. Section 12 talks of exclusion of time, the day from which the period is reckoned, and the time taken to obtain a copy of the decree or order is excluded. Okay. Leave to sue. Section 13. Time during which a person has been prosecuting a bona fide application for leave to sue as a pauper is excluded. Section 14. Wrong forum. Time spent prosecuting a case in good faith in a court which lacks jurisdiction is also excluded. Section 15. Stay of execution. Period during which the institution of suits has been stayed by an injunction or order is excluded. Section 17 talks of effect of fraud or mistake. Limitation starts only when the fraud or mistake is discovered or could have been discovered with reasonable diligence. Acknowledgement. Section 18. A written acknowledgement of liability signed by the party before the period expires starts a fresh period of limitation. Payment on account. Payment towards a debt or interest made before the period expires by the debtor starts a fresh period of limitation. Section 21. Substitution of party. If a new plaintiff or defendant is added, the suit is deemed instituted as to them only when they were joined. Continuing breaches. Section 22. In case of continuing breach of contract or tort, a fresh period begins at every moment the breach continues. Compensatory suit. Section 23. For acts not actionable without special damage, the period starts when the injury actually happens. Section 25. Easement rights. So right to light, air or way are acquired by peaceable and open enjoyment for 20 years and 30 years in case of government property. Extinguishment of right. Section 27. Exception to the general rule. So at the determination of the period for a suit for possession of property, the right to such property is extinguished. Suit for possession. Generally it is 12 years for suits relating to immovable property. Suits for money or debt. Generally it is 3 years from the date the debt becomes due. Suits for accounts. 3 years from the close of the partnership or the date of the last transaction. Filing appeals. Usually 30 to 90 days depending on whether it is to a high court or a district court. Special law. Section 29. Where a special law like IBC prescribes a different period, that period applies and section 3 is modified accordingly. Section 238A explicitly makes the Limitation Act applicable to proceedings before the NCLT and NCLAT. NPA and limitation. The 3-year period for IBC, section 7, starts from the date of default, not necessarily the date of NPA declaration. Extension via OTS. An offer for one-time settlement or a proposal in a balance sheet acts as acknowledgement under section 18. As per the Supreme Court ruling in case of Asset Reconstruction Company versus Vishal Jaiswal, entries in a balance sheet can amount to an acknowledgement of debt under section 18, thereby extending the limitation period for filing an insolvency application. So this is a critical check when evaluating time-barred debts in liquidation or CIRP proceedings. Next in this line is CPC, Code of Civil Procedure. लिमिटेशन एक्ट के ऊपर कुछ कमेंट्स नरेंद्र जी?
नो सर, नो।
ओके,
आ गया सर, सब आ गया सर।
चलो, ये है कि ब्रीफली देखो सारा कवर हो गया, बाकी तो मैंने डिटेल पीपीटी आपको दे रखी है, रिकॉर्डिंग आल्सो आई हैव शेयर्ड।
नहीं, वो टाइम ही पूछते हैं सर, वो जो 3 ईयर है, 30 ईयर है।
और वो जो डिटेल्ड पीपीटी है ना, उसमें तो पूरा शेड्यूल दिया हुआ है।
हाँ, और आपका वो वीडियो लेक्चर भी अच्छा है सर, उसमें भी 2 घंटे का है सर।
So this tabular chart summarizes points for CPC. Decree. Section 2, subsection 2. So decree conclusively determines the rights of the parties and it can be preliminary, final or partly both. Okay. Order. Section 2, subsection 14. Formal expression of a decision of a civil court which is not a decree. Judgment. Section 2, subsection 9. Statement given by the judge on the grounds of a decree or order. Masne profits. Section 2, subsection 12. Profits received by a person in wrongful possession of property. But it excludes improvements. Sub judice. Section 10. A court cannot proceed with a trial if the same matter is already pending in another court. Then res judicata. Section 11. So once a matter is finally decided by a competent court, it cannot be litigated again between the same parties. So if the subject matter is same, parties are same, then this concept of res judicata applies. Jurisdiction. Section 9. Civil courts have the power to try all suits of a civil nature unless expressly or impliedly barred. Section 15. Pecuniary jurisdiction. Every suit must be instituted in the court of the lowest grade competent to try it. Section 16. Suits for immovable property must be filed where the property is situated. Section 20. Other suits to be instituted where the defendant resides or the cause of action arises. Section 26. Every suit is instituted by the presentation of a plaint. ठीक है. Section 27 and verified by an affidavit. Section 27 talks of summons. So summons are issued to the defendant to appear and answer the claim within 30 days of institution. And courts can levy penalty also if they do not appear. Parties to suit. Order 1. All persons may be joined as plaintiffs or defendants if the right to relief arises from the same act. Order 1, Rule 9. It talks of rule of non-joinder. So failure to join a necessary party without whom no order can be made is fatal to the suit. Rule 8. Representative suit. One person may sue or defend on behalf of all persons having the same interest. Order 2. Order 6, Order 8. ये सारे orders हैं, which you can see. So this doctrine of res judicata is essential to prevent creditors from relitigating claims that have already been settled in prior civil proceedings. Additionally, the rejection of plaint, Order 7, Rule 11, is a powerful tool to dismiss frivolous litigation against the estate if the claimant fails to show a legitimate cause of action or if the suit is barred by law. Now regarding Transfer of Property Act. Preamble. So this Transfer of Property Act regulates transfers in vivos between living persons only, and it does not cover the transfers by operation of law. For example, inheritance or will, it is not covered. Section 3, it says that immovable property does not include standing timber, growing crops or grass. Instrument. Instrument means a non-testamentary instrument, a legal document for transfer. Attestation must be signed by at least 2 witnesses who saw the executant sign. Actionable claim, a claim to any debt other than secured debts or beneficial interest in movable property. Notice, it can be actual, direct knowledge or constructive, presumed knowledge through registration or possession. Transfer of property. So it is an act by which a living person conveys property to one or more other living persons. Section 6. What can be transferred? Generally all property, but spes successionis, mere chance of heirship, cannot be transferred. Section 7 talks of competency to transfer. So persons must be competent to contract and entitled to the transferable property. Oral transfer. A transfer of property may be made without writing in every case where the writing is not expressly required by law, but only 100 rupees is the limit. Section 10. Restraint on alienation. So conditions absolutely restraining the transferee from parties with his interest are void. Transfer for unborn. Section 13. Property cannot be transferred directly to an unborn person. It must be preceded by a prior life interest. Section 14. Rule against perpetuity. So no transfer can take place after the lifetime of one or more persons living and the minority of an unborn person. Section 19. Vested interest. It is an interest created in favor of a person without specifying time. It is not defeated by death before possession. Contingent interest becomes vested only on the happening of a specified uncertain event. Conditional transfer. Section 25. So transfer is void if the condition is impossible, forbidden by law, or involves injury to person or property. Doctrine of election. Section 35. If a person transfers property, he has no right to, the owner must choose to either confirm the transfer or defend or dissent. Ostensible honor. Section 41. It says the transfer by an ostensible owner with consent of real owner is valid if the buyer acted in good faith. Section 52. Lis pendens. So property under active litigation cannot be transferred so as to affect the right of any party to the suit. Section 53A. Part of performance. So it protects a transferee who has taken possession and performed his part of the contract even if the deed is unregistered. Definition of sale. Section 54. Transfer of ownership in exchange for a price paid or promised. Mortgage, the transfer of an interest in specific immovable property for securing the payment of property. Simple mortgage. In case of simple mortgage, possession is not delivered. Mortgagee has the right to sell property through court on default. English mortgage. Mortgager binds himself to repay on a certain date and transfers property absolutely to the mortgagee. Equitable mortgage, created by delivering documents of title or title deeds to the creditor in notified terms. Charge. Section 100, where immovable property is made security for payment without amounting to a mortgage. Right. Then lease. Section 105, a transfer of a right to enjoy property for a certain time in consideration of a price or rent. Determination of lease. Section 111. Lease ends by efflux of time, happening of an event, or forfeiture. Exchange. Section 118. When two persons mutually transfer the ownership of one thing for the ownership of another, not money only. And gift. Section 122. Voluntary transfer of property made without consideration and accepted by or on behalf of the donee. Now regarding negotiable instruments. MVS Kumarji, can you read for me?
Yeah, sure.
Yes, sir. Regarding this negotiable instruments act.
Yeah.
I
Critical
hope it
points.
is, yes.
Yes, yes. The Critical points, Negotiable Instruments Act 1881.
Hmm.
First is the definition of NI.
Hmm.
Section 13 means a promissory note, bills of exchange, or check payable to order or bearer.
Hmm.
Second, promissory note. Section 4, an unconditional undertaking in writing signed by the maker or to pay a certain sum.
Hmm.
Bills of exchange. Section 5, an unconditional order in writing signed by the maker directing a person to pay a certain sum.
Hmm.
Check. Section 6, a bill of exchange drawn on a specified banker and not expressed to be payable, otherwise they are on demand.
Normally, there is a common understanding. The definitions are given in section 2. But sometimes they make a question on this only. That negotiable instruments have been defined in which section. So definition of negotiable instruments is given in section 13, not in section 2. So this we must remember. Yes.
Characteristics. General, must be in writing, signed, freely transferable, and carries a presumption of consideration. Holder. Section 8, person entered in his own name to the possession of the NI and to receive the amount. Holder in due course. Section 9, person who becomes the holder for a consideration before maturity and without notice of any defect in title. Negotiation. Section 14, transfer of an instrument to another person so as to constitute what person the holder. Constitute that person the holder. Endorsement. Section 15, when the maker or holder signs the instrument otherwise than such maker for the purpose of negotiation. Endorsement in blank. Section 16, if the endorser signs his name only, it is an endorsement in blank, it becomes a bearer. Endorsement in full. Section 16, if the endorser adds a direction to pay the amount to a specified person. Ambiguous instrument. Section 17, where an instrument may be construed as either a note or a bill, the holder may at his election treat it as either. Inchoate instrument. Section 20, a signed blank or incomplete stamped paper gives the holder authority to complete it for any amount covered by the stamp. Liability of drawer. Section 30. If the drawer of a bill or check is bound to compensate the holder in case of dishonor by the drawee. Capacity minor. Section 26. A minor may draw, endorse, and deliver an instrument so as to bind all the parties except himself. Presentment for payment. Section 64. NI must be presented for payment to the maker, acceptor, or drawee by the holder. Maturity. Section 22. The date on which it falls due. The 3 days of grace are allowed on notes or bills not payable on demand. Dishonor by non-payment. Section 92. When the maker, acceptor, or drawee makes a default in payment upon being duly required to pay. Notice of dishonor. Section 93. Notice must be given to all parties whom the holder seeks to make liable, except the maker or acceptor. Noting. Section 99. A formal record by a notary public of the fact of dishonor. Protest section 100. A formal certificate issued by a notary public attesting the dishonor. Dishonor of check section 138. Criminal offense for insufficiency of funds punishable with up to 2 years imprisonment or double fine. Statutory notice section 138B. Notice must be sent to the drawer within 30 days of receiving information of dishonor from the bank. Payment period section 138C. Drawer has 15 days from receipt of the notice to make payment to avoid criminal liability.
So all these timelines, particularly which are given in section 138, these are important and they can ask a question on this. So we have to make specific notice of this section 138. Yes.
Interim compensation. Section 143A. The court may order the drawer to pay interim compensation up to 20% of check amount during the trial. Offenses by companies. Section 141. Every person in charge of company at the time of offense is deemed guilty. Material alteration. Section 87. Any material alteration renders the instrument void as against anyone who did not consent to it. Crossing of check. Section 123, 124. General or special crossing directs the bank to pay the amount only through a banker. IBC interplay moratorium. Section 14 IBC. Moratorium under Section 14 of IBC applies to Section 138 proceedings against the corporate debtor. Director liability. Case law. Directors or management remain liable under Section 138 even if the company is under CARP moratorium. Practical insight for insolvency professionals. As per the landmark judgment, P. Mohan Raj was Shah Brothers, while Section 138 proceedings are stayed against the corporate debtor during the moratorium period. The individual directors or signatories do not get the protection and the criminal trial against them can continue. This is a critical distinction to maintain during the CARP process.
So even this case, P. Mohan Raj is also in our syllabus. So it says that proceedings can continue against the directors. Yes. Now regarding sale of goods act.
Yeah.
एक बार पढ़ लीजिए हाँ जी.
Contract of sale. Section 4 includes both a sale, immediate transfer, and an agreement to sell, future transfer. Subject matter. Section 2, subsection 7. Goods means every kind of movable property other than actionable claims and money. Existing goods. Section 6. Goods physically in existence and owned by the seller at the time of the contract. Future goods. Section 2, subsection 6. Goods to be manufactured or acquired by seller after making the contract. Perishing of goods. Section 7. Contract is void if specific goods perish without seller's knowledge before the contract is made. Price fixation. Section 9. Price may be fixed by the contract, agreed manner or determined by the course of dealings. Stipulation as to time. Section 11. Time of payment is not of essence unless specifically agreed in the contract. Condition. Condition. Section 12, subsection 2. A stipulation essential to the main purpose. Breach gives a right to repudiate the contract. Warranty. Section 12, subsection 3. A stipulation collateral to the main purpose. Breach gives a right to claim damages only. Implied title. Section 14. Implied condition that the seller has the right to sell the goods. Sale by description. Section 15. Implied condition that the goods shall correspond with the description. Caveat emptor. So section 16, let the buyer beware. The buyer must check the quality subject to the specific exceptions. Fitness for purpose. Section 16(1). Implied condition of fitness if the buyer makes known the purpose and relies on seller's skill. Merchantable quality. Section 16(2). Implied condition that goods bought by description from a dealer or of a merchantable quality. Sale by sample. Section 17. Bulk must correspond with a sample in quality. Buyer must have opportunity to compare. Transfer of property. Section 18. Property cannot pass on unascertained goods until they are ascertained. Specific goods. Section 20. Property passes when the contract is made if the goods are in a deliverable state. Goods on approval. Section 24. Property passes when the buyer signifies approval or retains goods beyond a reasonable time. Nemo dat rule. Section 27. No one can give what he has not. A buyer gets no better title than seller had. Mercantile agent. Section 27. Exception to the Nemo dat. Sale by a mercantile agent in ordinary course of business is valid. Delivery. Section 2, subsection 2. Voluntary transfer of possession from one person to another. Symbolic delivery concept. Delivery by handling over the means of control like keys to a godown or document of title. Rules of delivery, section 36. Delivery of goods and payment of price are concurrent conditions unless agreed otherwise. Wrong quantity, section 37. If the seller delivers more or less than contracted, buyer may reject all or accept and pay at contract rate. Unpaid seller, section 45. A seller to whom the whole of the price has not been paid or a bill of exchange has been dishonored. Seller's lien. Section 47. Section 47. Right to retain possession of goods until payment, provided the seller is in possession. Stoppage in transit. Section 50. Right to resume possession of goods while they are in transit if the buyer becomes insolvent. Right of resale. Section 54. Unpaid seller can resell perishable goods or after giving notice to the buyer. Suit for price. Section 55. Seller may sue the buyer for the price if the property has passed on a specific date. Then auction sale, section 64. Sale is complete when auctioneer announces its completion by fall of the hammer,
So the main points which we have to remember in sale of goods are, one is regarding this condition and warranty. This is important. So if there is a stipulation which is essential to the main purpose, so breach will give a right to repudiate the contract, and warranty is somewhat lesser damage, stipulation collateral to the main purpose. So breach will give right to claim damages only. Another important thing is the concept of this caveat emptor, let the buyer beware. So these are few important concepts. They can ask you question on this, and then they can ask questions on the rights of unpaid seller. So unpaid seller has right to retain possession of goods until payment, stoppage in transit, right of resale, and so for price. So these are the main important things which we have to remember in case of sale of goods. Now regarding contracts, let us see the main points regarding contracts.
Contingent contract, section 31. A contract to do or not do something if some event collateral to such contract does or does not happen. Enforceability.
So what we have done is here in case of Indian Contract Act, we have asked them some major points on this agency, contingent contracts, breach of contract, and indemnity or guarantee. So these are the main points we have covered in case of Contract Act. Yes, please.
Enforceability, section 32. Contracts contingent on an event happening cannot be enforced until that event has happened. Event impossible, section 36. Contingent agreements to do anything if an impossible event happens or void. Breach of contract. Anticipatory breach occurs when a party refuses to perform their obligation before the due date. Remedy for breach, section 73. The aggrieved party is entitled to receive compensation for any loss or damage caused. Remote damages, hardly possessed box and tail. Compensation is not given for any remote or indirect loss, only for natural consequences. Liquidated damages, section 74. If a sum is named in the contract as the amount to be paid in case of breach, the party is entitled to reasonable compensation. Quantum merit remedy. As much as earned, a party can claim the value of work already performed if the contract is breached.
So sometimes they ask a question of this, quantum merit, as much as is earned. Suppose you hire a painter for 5 days, and after 1 day, he does not turn up, then he is entitled for 1 day remuneration for as much as he has done the work. Yes, please.
Specific performance remedy. A court order requiring a party to perform their specific contractual obligations. Injunction remedy. A court order restraining a person from doing a particular act. Negative covenant. Contract of indemnity.
Now, what is the example of this injunction? Suppose a singer has entered into a contract that, okay, he will be performing at your function, but he refuses to perform at your function. He says, I am not available. But you come to know that he is performing at some other place. So now an injunction order can be obtained in that case. So what the court will say? The court order will say that you cannot perform at any other function if you are not performing at this function for which you had already agreed. So this is the meaning of injunction. Now specific performance is there in case of, say, In case of contracts where money is not the adequate consideration, say a contract for painting, right? Or some other such thing where specific performance is important. Yes, please. Contract of indemnity.
Contract of indemnity. Section 124. A contract by which one party promises to save the other from loss caused by the conduct of the promiser or any other person. I think you need to scroll.
Just a minute. Yes. Contract of guarantee.
Contract of guarantee. Section 126.
Hmm.
A contract to perform the promise or discharge the liability of a third person in case of his default. Parties in guarantee, tripartite agreement involves three parties: principal, debtor, creditor, and surety. Surety is liability, section 128. The liability of surety is coextensive with that of the principal debtor. Continuing guarantee, section 129. A guarantee which extends to a series of transactions. Revocation of guarantee, section 130. A continuing guarantee may at any time be revoked by the surety as to the future transactions by notice. Discharge of surety, section 133. Any variance made without surety's consent in terms of contract discharges surety. Agency definition, section 182. An agent is a person employed to do any act for another or to represent another in dealings with third persons. Capacity to be agent, section 184. Any person may become an agent, including a minor, but they cannot be held responsible to their principal. Consideration in agency, section 185. No consideration is necessary to create an agency. Ratification, section 196. Where acts are done by one person on behalf of another without his knowledge, he may elect to ratify or disown such acts. Agent's duty, section 211. An agent is bound to conduct a business of his principal according to the directions given by the principal. Personal profit, section 216. If an agent deals on his own account in the business of agency without principal's consent, the principal can claim any benefit made. Agent's lien, section 221. An agent is entitled to retain goods, proper and property of principal until the amount due to him is paid. Declarator agent, special agent, an agent who for extra commission guarantees the solvency of the third party to the principal. Termination of agency, section 201. Agency is terminated by the principal revoking authority, the agent renouncing the business, or death or insanity of either. Irrevocable agency, section 202, where the agent has himself an interest in the property which forms subject matter of agency. Sub-agent, section 191. A person employed by and acting under the control of original agent in the business of the agency.
तो नरेंद्र जी, डेल क्रेडिटर एजेंट क्या होता है? डेल क्रेडिटर एजेंट क्या होता है ये?
एक्स्ट्रा कमीशन गारंटी फॉर सॉल्वेंसी ऑफ थर्ड पार्टी।
हाँ, मतलब समझाओ ना, इसका क्या मतलब है? भाई देखो, प्रिंसिपल है, प्रिंसिपल कहता है भाई देखो मैं तो इस पार्टी को जानता नहीं। तो डेल क्रेडिटर एजेंट क्या कहता है? वो कहता है देखो जी, मैं इस पार्टी को जानता हूं और पेमेंट की श्योरिटी है, आप चिंता मत करो, पेमेंट आ जाएगी इस पार्टी से, और पेमेंट डूब गई तो मैं जिम्मेदार हूं। ठीक है? तो एक किस्म से वो गारंटी ले लेता है कि भाई ये पेमेंट कर देगा बंदा, परचेजर जो है। ये होता है डेल क्रेडिटर एजेंट। चलिए।
Principal's liability, vicarious liability. The principal is liable for the frauds or torts committed by the agent in the course of the agency business. Novation, section 62. If the parties to a contract agree to substitute a new contract for it, original contract need not be performed.
सो इसमें मेन पॉइंट एक तो ये है कि इंडेमनिटी और गारंटी में व्हाट इज द डिफरेंस बिटवीन इंडेमनिटी एंड गारंटी?
Guarantee, three parties are involved.
Okay, yes. In case of indemnity?
Party.
So basically indemnifying the liability.
Right, very correct. So two parties are there, indemnifier and the indemnified. So in case of guarantee, there are three parties: principal, debtor, creditor, and surety. But in case of indemnity, only two parties are there: indemnifier and indemnified. right.
What
Now,
about the bailment? It is not covered here. Is it not important?
a bailment, yes. So bailment will specifically cover, no issues. Bailment will specifically cover. I have given it in the that
Normally, these
PPT.
aspects cover even bailment also. Bailer, bailee.
Yes, yes, yes. Just a minute. Sale of Goods Act. So what we can do, we can just now see.
Or we'll continue this.
We can cover from here, Sale of Goods Act, bailment. Yes. So we can cover from here. Let us quickly cover this bailment also, no issues. So this PPT I have already shared with you. So what it says. Now what is bailment? So bailment is the delivery. I hope it is clear. I hope it is visible to you. Right?
Yes, 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 yes.
So, now, so bailment is the delivery of goods by one person to another for some purpose. Upon a contract that they shall, when the purpose is accomplished, be returned or otherwise disposed of according to the directions of the person delivering them. The person delivering the goods is called the bailer. The person to whom they are delivered is called the bailee. You give your coat to a tailor for stitching. This is a contract of bailment. You give your watch for repair. It is a contract of bailment. It could be gratuitous bailment. It could be for consideration. You give your car keys to your friend. You are going abroad for 6 months and you ask him to take care of the car. So this is also a contract of bailment. Care to be taken. Bailee when not liable for loss. Termination of bailment. Liability of bailee making unauthorized use of goods. So these are the things which are important.
I mean, pledge also to be covered. Pledge.
Yes. So pledge is a specific, right? But
I think these are all the special contracts it will cover.
right.
That's why
Mhm.
Panar Pani, something like.
Yes. So you can go through this. Now let us continue with the presentation which we were seeing. Huh?
Yeah, we'll continue.
Just a minute. ये तो- यहाँ पर थे हम लोग. Just a minute. Yes. Just a minute. Yeah, I hope now it is visible, है ना? Visible है ना?
Yes, yes, yes.
Page number 21, sir.
हाँ, अभी देखो. ये शेड्यूल हो गया हमारा. ये हो गया. अब हम चलते हैं ये. पार्टनरशिप इसमें इतना इंपॉर्टेंट नहीं है, बाकी ये देख लेते हैं हम लास्ट वाला इसका, दूसरा जो है ये। ये कंपैरिजन चार्ट पढ़ लेते हैं रिगार्डिंग दिस पार्टनरशिप। यस प्लीज।
Core concept. Comparison chart, admission, expulsion, and dissolution. Core concept. Admission of partner, section 31. Expulsion of partner, 33. And dissolution of a firm, 39 to 44. Core concept. Entry of a new person is a partner. Removal of an existing partner against their will. Complete breakdown of the relation between all the partners. Consent requires consent of all existing partners. Expulsion cannot be done by majority unless power is in the contract. Dissolution can be by consent, notice, or court order. Good faith, based on the mutual trust for future business, and must be exercised in absolute good faith.
आप ना इसके साथ हेडिंग भी पढ़ लो, एक्सपेल्शन मस्ट बी एक्सरसाइज्ड इन एब्सोल्यूट गुड फेथ, ऐसे करके है ना।
Okay.
एडमिशन शुड बी बेस्ड ऑन म्यूचुअल ट्रस्ट फॉर लाइक दिस।
Okay. Admission based on the mutual trust for future business. Expulsion must be exercised in absolute good faith. Dissolution usually occurs when substratum of business is gone. Notice requirement. Admission not applicable, agreement based. Expulsion irregular without a notice or opportunity to be heard. Dissolution mandatory in partnership at will, section 43. Scroll up.
Continuity.
Continuity. Admission, firm continues to exist. Reconstitution.
Expulsion.
Expulsion, firm continues with the remaining partners. Dissolution, firm ceases to exist as a going concern. New liability. Admission, liability starts from the date of joining. Expulsion, liability for the past acts continues until the public notice. Dissolution, liability for the post-dissolution acts continues until the public notice. Past liability. Admission not liable for acts done before admission. Expulsion continues to be liable for acts done while a partner. Dissolution, all partners remain liable to third parties until notice. Public notice. Admission not mandatory for the act of entry. Expulsion mandatory to terminate future liability. Dissolution mandatory to protect partners from third party claims. Right to profits. Admission gains right to share in future profits. Expulsion entitled to share of profits or interest until final settlement. Dissolution, assets are sold to pay debts. Surplus is distributed. Business operations. Admission, business expands or stays same. Expulsion, business continues without a expelled person. Dissolution, business is wound up, only winding up acts allowed. Role of contract. Admission governed by the partnership deed. Expulsion must be specifically authorized by the contract. The dissolution can be triggered by contract. Example, expiry of term. Compulsory event. Admission never compulsory. Expulsion never compulsory, discretionary power. Dissolution compulsory if business becomes unlawful, section 41. Court intervention. Admission, court cannot force an admission. Expulsion, court can declare expulsion null or void if bad faith. The dissolution, court can order dissolution, insanity, misconduct, etc. So minor status. Admission, minor can be admitted to benefits only. Expulsion, minor cannot be expelled in the same legal sense. Dissolution, minor's share is liable for firm debts during winding up. Settlement of accounts. Admission, capital is introduced by the new partner. Expulsion, outgoing partner share is calculated and paid. Dissolution, final settlement of accounts as per section 48. Goodwill. Admission, new partner usually pays for goodwill. Expulsion, expelled partner may be entitled to share of goodwill. Dissolution, goodwill is sold as an asset, section 55. Restraint of trade. Admission not applicable. Expulsion can be restrained from similar business if in contract. Dissolution, partners can be restrained from using firm name. Effect on agency. Admission, new partner becomes an agent for all. The expulsion, agency of the expelled partner is revoked. dissolution, mutual agency terminates except for binding up. Forms to be filed. Form E, admission. Form E, notice of change in constitution. Expulsion. Form E, notice of cessation. Dissolution. Form E, notice of dissolution. Identity of the firm. Admission remains the same legal entity. Expulsion remains the same legal entity. Dissolution, the entity is extinguished post liquidation.
LLP. These are the forms.
Hmm.
So you can go through these forms. तो हमने इसमें क्या किया, फॉर्म्स भी दे दिया और पेनल्टी भी दे दिया जनरली। बस आज का यही कथा समाप्त करते हैं।
Okay.
तो आज हमने पूरा कवर कर लिया इसको।
हम्म।
तो फास्ट फॉरवर्ड मोड में